Wherever there's political violence, we find propagandists who incite their followers to commit mass crimes. Instinctively, we feel they bear responsibility for inciting violence, but it's very difficult to hold them accountable in a criminal court. My research explains why speakers who incite others to commit crimes often elude prosecution and judgment. My name is Richard Wilson, and I'm the Gladstein Chair of Human Rights and Professor of Law and Anthropology at the University of Connecticut. Now, there are good reasons for courts to be cautious about restricting speech. Democracy requires freedom of expression. Each person is responsible for their own actions, regardless of what another person might be encouraging them to do. But there are other factors that are peculiar to the legal process. I discovered this when conducting research on the Nuremberg trials in the Dodge Center's archives and special collections. As they built their case against Nazi propagandist Julius Streicher, prosecutors such as Thomas Dodd found testimonial evidence from a stormtrooper that linked Streicher's newspaper to the killing of a Jewish family in the 1930s in Germany. However, the prosecution decided not to use this causal evidence because it wanted to focus on the actual published words of Streicher, who explicitly called for the extermination of the Jews. They were concerned the defense might be able to poke holes in the connection between Streicher's words and a specific outcome. Instead, prosecutors decided to build their case on the genocidal intentionality expressed in the words themselves. But are words enough? This brings us to one of the biggest problems in trials of speakers who incite violence, insurrection, or genocide. Do we focus on the words of the speaker or the context in which the words are uttered? The answer is both. But courts need more guidance on how to assess context. In Brandenburg versus Ohio, a U.S. Supreme Court case from 1969 in which a Ku Klux Klan leader called for a march on Congress, the court said that a speech could only be suppressed if it advocated the commission of a crime that was imminent and likely to occur. Yet the Supreme Court in Brandenburg gave no guidance on how we should determine what is considered imminent and likely, nor what contexts are the most dangerous. So prosecutors are reluctant to proceed when there's such uncertainty about the evidence they must bring to prove a crime. This is one reason why inciters are seldom tried in the United States. This is an especially pressing problem in our current environment in which highly polarized political discourse takes place on social media. How do we preserve the freedom of expression needed for democracy without allowing inciting speech to destroy democracy? Some want to suppress all speech they find offensive, whereas others champion absolute freedom of expression. Social science can help us to create a middle ground. We know a lot about the conditions in which a speaker is likely to persuade an audience to act in a violent manner. Along with my co-researcher Jordan Kuiper, I've created a 10-point matrix that identifies the conditions in which an inciting speech is likely to result in imminent violence. We know, for instance, that the authority of the speaker, the graphic nature of their speech, and the emotional state of the audience are all key risk factors. In regulating speech that threatens or incites violence, we have to chart a careful middle path based on research that allows democratic deliberation to take place, but which protects our most vulnerable citizens as well as our democracy.